Hi, it's the Decoding IP team bringing you our everyday IP chat. We talk about intellectual property and technology issues that are making headlines. We try to talk in plain English so that you can understand how these issues might impact your life and your business. We hope that these chats are informative and fun and help you find, grow, and protect your content and creations. I'm Jennifer Atkins. I'm joined today by Kandis Koustenis, my colleague here at Protorae Law. And today we're going to talk about trademark, and we're going to talk about who's first. And I'm really, really excited about this because I get to make a who's on first joke, which I essentially have been waiting all of my life to do. So, when I was talking about this, like, who's on first? Who's on first? We are not, unfortunately, though, going to be talking about baseball, right?
Thank goodness.
Thank
goodness we're not.
Even though the Nats did win last night.
Very much.
Right?
Okay.
The Nats did win last night in the trifecta of Washington teams playing last night. The only one to win was the Nats, kind of at the very dramatic ending. But we're not going to be talking about baseball today. What we are going to be talking about is the concept in U.S. trademark law and in trademark law generally, who gets priority. The first person to use a mark or the first person to file and register a trademark, right?
Right.
So Kandis is our kind of resident trademark guru. Let's talk a little bit about the concept of first use versus first file kind of around the world and in the US.
Okay. Well, in the United States, which is in the minority, trademark rights are built through use of the trademark. And most people know this. So in order to earn trademark rights, one only has to use it and use it out in the public with sale of your goods or services. And just by virtue of your using the trademark in commerce, you are acquiring trademark rights. In many countries outside the United States, in Europe and Asia, for example, rights are based on who files an application to register first.
So it doesn't matter if you've been using it.
It doesn't matter if you've used the mark. If you just file for the registration, you will be the first priority user. Well, first priority, you will have priority, whether you've used or not. Now, the laws then do say that for a period of years after that registration, one can come forward and move to cancel. It's depending on the country, it's a 3-year period or a 5-year period. So yes, you get the benefit of, I'm not using it all. I'm going to file for this trademark registration and I will be the owner. But if you don't use within 3 or 5 years, depending on the country, then a user can move to cancel your registration. But again, as we're going to talk about, that means you've got to spend the money. You've got to file an action. And this is why you hear stories about, big companies who forget to file some of their most important trademarks in countries in China.
Particularly in
China,
Asia,
for example.
And
they will find out that there is someone who realized that they hadn't filed for their very well-known trademark in China. They have done it, they have obtained prior rights, and they therefore usually walk away with a good chunk of change because they simply forgot to file the registration. But in the US, it is use-based. Canada is also. But there are aspects in the United States that folks need to be aware of. And this case is a good example of it, because while it is a use-based jurisdiction, which is what we say when you acquire your rights through use, there are things that come into play when you file applications to register in the United States. And that is when we talk about benefits to registration. This really highlights that.
So when Kandis is talking about this, what we're talking about today and why this came up, not just because I wanted to make baseball related jokes on the show, why this came up is because there is a case that has gotten some media attention, enough that a couple people mentioned it to me, called Nexsan versus EMC. And it really, really illustrates the issues that come up between use and registration, right? And how we decide who gets to use a trademark. And these things, sometimes they're little, but a lot of times this is a huge investment that's been made in branding and marketing. And so So we're not talking about baseball. We're talking about two companies that do data storage, which sounds kind of unsexy, but is massively important, right? EMC and Nexsan.
And they had a nice trademark.
Right.
I like the trademark.
Right.
Yep.
So EMC and Nexsan are both companies that do digital data storage. EMC back in 2014 or 2015, depending on whose version of the facts you believe, started coming up with a new suite of products and software things for data storage. They decided they were going to call this suite of products Unity. A really nice name.
Yep.
They came up with.
I like it.
And I think, Kandis, you're a little more familiar with the facts of the case than I am, but basically they sort of started this back in 2015 and they were developing their product and they were beta testing and they were talking to customers about it. But
in the meantime, Nexsan also decides that they like the name Unity. Now, whether or not they actually were aware of EMC's use, that's
hard to tell.
That's an issue. That was an issue, but really, Nexsan did what one is supposed to do when they become interested in using a particular trademark. They conducted a search of the PTO registry. Because EMC had not filed an application, there was no notice on the PTO site. And so Nexsan says, great.
Unity's available.
PTO's clear. Let's do an internet search. Because, of course, we all have to remember that, because the United States is a use-based jurisdiction, you get your rights through your registration. But just because the registrations are clear doesn't mean there isn't a user out there. So you also want to check for what's called common law use, which means typically if you're not hiring an investigator to do an expensive search report, you'll at least get on the internet and get on the internet and do a search, which Nexsan did. Again, found no evidence of EMC's use of the trademark Unity, which
they might have found a blog post or something by somebody that maybe mentioned it, but it's not really clear.
Well, and obvious, and then again, blogging and private use where you're not using something out to the public in connection with your sales.
Yeah.
In connection with your sales. That isn't really considered use.
Yeah.
So, but in any event, Nexsan did enough to make them look, like enough of a do-gooder. They did clear the mark, whether, they may have had some inkling that their competitor was using this, but, they decided, okay, great. We really like it. We're going to file what are called intent to use applications for the mark. Should we talk about intent to use applications?
Yeah, I was going to say
okay.
that actually makes sense. So kind of pause here. So we're in this world where, EMC has been thinking about it and they're developing their product, but they're not using it really out in public yet. They might be using it internally, but certainly thinking about Unity. Nexsan, on the other hand, sort of comes up. They think, I think our next data storage product, we're going to use the word Unity. And instead of sort of continuing to develop, they say, we're going to tell the trademark office we intend to use this word, right?
Mm-hmm. Right. And if I had been counseling EMC at the time that they were conducting all of these presentations and the beta testing, and expending significant amount of dollars and time in developing this product suite that they fully intended to use the name Unity in connection with, I would have said, this is the ideal time to file what's called an intent to use application. And that is what Nexsan did, a year later.
Yeah.
So,
this is interesting. So we got, we got a question.
Okay.
Does a repeated use of a term in social media establish common law ownership? So this is really interesting. This gets to this issue of what is use. And under trademark law, it's really use in commerce, right? Mm-hmm. And so what a court will decide, or the TTAB will decide, is use in commerce. Can vary. So it really, really depends on context.
I mean, every time a client calls me and wants to know, is this enough, or is this something that I should be concerned about? I always say I have to see it. because it's all about context. So if someone is using a term in social media, but they're using it as a catchphrase, for example, or it's just part of the public discourse, like the "nevertheless she persisted."
Yeah, it's not a
things
trademark.
like that. That is not considered trademark use because it isn't being used to identify a particular source. That's what a trademark is meant to do. It identifies one particular source of goods or services. You don't necessarily have to know who that is. So when you see Snickers, you don't need to know that that's Mars. But you know that when you see a Snickers bar, that it's coming from one particular source in connection with the sale of the candy bar.
Right.
So just using terms on social media doesn't necessarily rise to the level of trademark use. And in fact, could hurt your chances of having it be considered trademark use because you're using it as discourse, as words in the English language, not necessarily to identify the source of your sale of goods or services.
Right.
So an intent to use application is something that, even though the US is a use-based jurisdiction, we have this, and it's a very nice benefit. Clients have it within their budget. I recommend doing it because it essentially is the ability to file an application before you have started actually using the trademark. So before you can show this actual use in commerce, but you have a bona fide intent to use, which means you're taking real steps to get to the point where you're using the mark in commerce, which EMC definitely had.
Clearly they were,
They were taking steps. They were, and especially when it gets to the point where you are investing sums of money. If you are investing sums of money surrounding a particular trademark use, well, file your intent to use application, because that draws your line in the sand. That's
Put
how
your mark
I like to describe it that way. I mean, it kind of puts, it's a placeholder. That becomes the filing date of your intent to use will become once you obtain your registration, but that filing date of your intent to use will become your actual use date, and that will be your priority date. And so you do have the ability to perhaps have priority over someone who was actually using before your intent to use application.
Right.
And that's kind of what ended up happening here. Same thing with a use-based application. So benefits of registration, whether that's via an intent to use application, which is as soon as you start putting money into a particular trademark and you have it within your budget, let's file an intent to use because that's your placeholder. That's your line in the sand. But even if you're already using and you file your use-based application, the filing date of your application will also become the marker against which the trademark office, for example, will measure third parties who come in. So even if your actual claim date of use is after someone else's use, but your filing date is first, when the second comer comes in to file an application, they will still get refused based on the earlier filed application. So that's not to say that the arguments don't exist, but like we were saying, what that means is you don't just automatically win. Right. You have to take action, and that's expensive. You've got to take action in federal court, or you've got to take action before the TTAB.
Right. So getting back to what happened in the case here. So we're at this place sort of in the case facts where EMC has been thinking about this and doing beta testing and all of this, giving things to customers, but under really strict confidentiality agreements, right? Like trying to not let the details of this project that they're working on get out. On the other hand, Nexsan, 2016, a year later, comes in and says, hey, we like this name Unity. We're going to launch a new product line. We're going to go ahead and file this intent to use. We're not using it yet. We haven't really told anybody yet, but we like it. We're going to put our marker down. And then, we're going to use. So EMC, a month or two after Nexsan sort of has filed their application, EMC goes to their product launch and at the same time opposes the application of Nexsan in the trademark office. And this is actually sort of another interesting practice piece of this case, right? So so Nexsan opposes in the trademark office, EMC opposes Nexsan in the trademark office, and Nexsan, instead of staying in the trademark office to fight this out, files a declaratory judgment action in federal court.
Yeah,
really smart strategy on their part.
Smart strategy, because we have what's called the Trademark Trial and Appeal Board in the TTAB, and that's where you can do oppositions and cancellations, and those are little mini litigations involving the trademark rights, or you can go to federal court. While they ostensibly they do apply the same law and the same standards, in practice, they're a little bit different.
Yeah.
And so one of the things I was saying to Jennifer when I said, they actually opposed, but then Nexsan filed a district court action and then said to the TTAB, you have to suspend, which is what happened. So if someone files a district court action and that relates to something that's ongoing in the trademark office will stand down and wait and abide by the district court's ruling. And so I was saying to Jen, if this had been the opposition had gone forward and Nexsan had not filed in district court but had stayed within the TTAB, I think EMC might have had slightly better chances, just given, my gut about how the TTAB rules on these cases. And, and I had an opportunity to look at this for a client recently. So very good strategic call on behalf of Nexsan's attorneys.
So they go into federal court and the issue becomes, and the court sort of says, here's what EMC makes the argument. We're a use-based jurisdiction. We used it, right?
We're the prior
user. We've been using it since 2015. They shouldn't be allowed to trademark it. And Nexsan says, hey, wait a minute. No, you weren't using, because we didn't see that you were using, and we're legitimate and we should get the benefit of filing our intent to use. And that's where we stand, right? So then the district court has to go through the evidence and say, all right, EMC, what are you show me?
Yeah, show us what you've been doing.
Yeah. And so they do, and they start going down this litany of things, trying to show that they had used this term. The district court didn't really dispute that they had decided on this name Unity.
Yeah, right.
But the district court said, hey, look, you used it internally, but you also used all these project code names, and it wasn't really clear. You didn't use it consistently internally, but internal use doesn't really matter.
It's not trademark use in commerce.
Use in commerce, right? The statute says use in commerce. And so then they said, well, but wait a minute. When we were doing all the beta testing, we were sending it to customers. We were having our customers test it for us. Again, there was some inconsistency in whether they really called it Unity or not to their customers, but there was a fair amount.
There was some use of the, when people say project XYZ.
Yeah.
So there was some use of that, but there was some use of Unity.
But the customers were bound by really, really strict non-disclosure and confidentiality agreements. So there was kind of inconsistent use of the term. There was consistent use of really strict confidentiality agreements. Same thing where they sort of were making presentations about what their products were going to be, again, sort of under very strict confidential stuff. And the court basically looked at that and said, well, it's great. You clearly chose this name and you were communicating it to some customers, but you were not using it in commerce. You were not using it. It was not publicly disclosed.
Sufficient trademark use. Right. There's use, and then there's defined trademark use. And
so, one of the things that I think is, and the course of the court said Nexsan wins. Nexsan gets to use this word Unity. Sorry, EMC. You don't get to use it. And basically they're sort of in the exact same product world. So a coexistence agreement really isn't that possible here, nor I think was anybody interested in it. But, and I guess one guy who worked for EMC or had some connection with EMC wrote a blog post where he used the name, but again, it was sort of this unofficial thing. It wasn't on behalf of EMC. It wasn't in connection with selling
services or the goods.
Yeah. So, but But this actually raised something that we deal with all the time with clients too, which is, you know, as you're developing new products, new technologies, new whatever, something you're going to launch, you try to keep it really close to the vest, right? Particularly in the technology world where you might be looking for patent protection, right? Because in the patent world, you have to be really careful. Disclosure, public disclosure could limit your ability.
Could bar your patent rights.
You could end up without the ability to get patent right. And so there is this tension between the intellectual property regimes, right? Which is, I am sure what they were thinking of, or I mean, not sure, but I can project like what they were thinking of was,
let's protect our trade secrets. Let's protect our potential patent applications, you know, protect.
Yeah. And that can really hurt you on the trademark side because protect means you're not getting your trademark rights through use in commerce, right? Which brings us back to the great intent to use application, which you absolutely can do. And there are ways that, you know, trademark applications are not detailed disclosures in the way patent applications are, right? You can apply with an intent to use and say, this is the category of goods, data storage, and you're not giving anything away. Right. I mean, you can be sort of broad.
Yeah.
Right?
I mean, certainly with the initial application.
Yeah.
So if a client said to me, so if EMC said, well, right, but we're concerned about filing an intent to use application because we don't want anyone to know that we are out there developing a new particular suite of data storage products. And you know, and they're specified in a detailed way. I would say, okay, but we can file the intent to use application. We can make the description of services somewhat broad, vague, so that you're not necessarily giving away right away with the filing of the application. We'll likely get an objection from the examining attorney and we'll have to specify down the road, but that's down the road.
Right. That gives you time.
We can kind of kick the can on the problem, you know, but in the meantime, get your placeholder.
Yeah. Absolutely. And so that really sort of that difference between, you know, use and registration and, you know, we always say benefits of registration. So one of the things too, that people always ask me, I love doing this stuff because people will randomly come up to me at like a cocktail party and be like, so tell me what this means in trademark law. So one of the things that you see a lot, on things is the TM symbol or the little R with the circle, and those kinds of things. And people are always like, what does that mean? What does that mean? There you go. So I actually was going through and like finding the symbols in Microsoft Word to like put them up there. Right. So the R means it's registered, right?
Correct.
The R means it's registered. So if you see, you know, Coca-Cola with the little R in the circle, that's a registered trademark. You can claim trademark rights without registering TM. Like, this is my little trademark. I'm here using it. I haven't registered yet, but I'm here in commerce using it, and I'm indicating to the world, I'm raising my hand and saying, you know, this is my trademark, right?
My trademark.
And I'm out using it. So that's a little throw aside there for use, but you know. Again, here EMC didn't use that. There was no Unity TM on anything, right? Like,
right.
That was the, you know, in addition to the fact that there was sort of no real use in commerce, but you know, the reason this made news and the reason it sort of made waves with people was there was this reaction of like, hey, wait a minute,
it feels like first
use,
to file,
right?
And it feels like, well, wait a minute. I thought that, you know, it's been drummed into our heads that the United States is a use-based, you know, jurisdiction, and we acquire our trademark rights through use. This sounds like first to file.
Yeah, it sounds like, wait, are we turning into a first to file jurisdiction?
Right. But you have to really understand, you know, what is sufficient use.
Yeah.
You know, there's use, and then there's trademark use within the law. And I mean, even here, there's a slightly relaxed standard where if you're trying to show prior use against someone like a Nexsan who's filed an application, you can also argue what's called analogous use.
Yeah.
So even under the slightly less strict standard of analogous use, EMC didn't quite make it.
Yeah.
And again, that's because you still have to show sufficiently public, widespread use so that even though you're not actually using in commerce, you're going to have a sufficient number of people in the public who recognize that you're using it as a trademark.
Right.
And, they just didn't have sufficient, consistent public use. And I think, that the confidentiality of it all, the secrecy of it all really kind of made it easier for Nexsan to convince the judge here.
Yeah. That's right.
So, big takeaway when you're talking to your intellectual property attorneys, and this is sort of our mantra, strategy, and holistic approach, right? There's IP, but they're so interrelated. Trademark, copyright, patent, trade secret, they all intertwine. So we like to look at something holistically when a client comes and says, we want to start a new suite of data storage products, and this is what we're going to do. Don't look at what do we do under patent in a silo, separate and apart from, oh, well, are you planning on using this in connection with a particular trademark? Really? Oh, maybe we file an intent to use application. You have to have that discussion across your IP regimes, and they have to communicate with each other, which is...
Yeah, I mean, this is definitely something we run into all of the time and talk to people about, is that really you can't just, and a lot of times clients will come and say, they're so focused on patent, right? So focused on patent or so focused on copyright that they're, and obviously, we'll ask the question, well, what about trademark? What about copyright? What about patent? What about trade secret? Like, how are you, there is this whole host of ways to protect your intellectual property. And oftentimes you have to figure out courses of action that are different, right? So here, confidentiality, we're protecting our trade secrets, we're protecting our potential ability to patent, we're protecting all this, we're thinking about that. And we totally lost sight of trademark and what it means to develop and have a trademark,
and lost that third leg of the stool,
right? And spent a lot of money doing it too, right? Yeah. Where, I mean, I'm sure, like, sort of looking backwards and 2020 hindsight always, but someone over there has got to say, well, geez, if we had spent a small amount of money on an intent to, a trademark search and an intent to use application, if we had picked up the phone and called and done that, man, we would have saved a lot of money and a lot of time and a lot of heartache.
I am sure that the cost to file an intent to use application is significantly less than the attorney's fees spent in the opposition for the Trademark Trial and Appeal Board.
And then in court.
And then in federal district court, where you're really getting into,
it's a lot.
Big dollars.
So big takeaway one is it's not a silo, and
look at the whole big picture,
right? And talk to your IP attorney, make sure your IP attorney is,
if they're not asking the questions, you put it all out on the table.
Yeah. Because that is definitely something that, is so critically important, for everyone to kind of step back and look holistically and think about the intellectual property regime as a whole. And how are we going to use this to protect our assets, protect our content and creations, as we always say. Right. And then the second takeaway really is registration.
Right. I mean, it sounds like a big commitment. And especially when you're working on a limited budget and you're just like, really, I've got to, spend this money. But if you think about it, it could potentially save you lots of money down the road. Yeah. Because even if EMC was able to prove their actual use in commerce, the fact of the matter is, how much money did they have to spend in order to get there?
Yeah.
I mean, I had a client who her marks, her registrations had been allowed to go abandoned.
It happens.
It happens. She didn't have anyone checking her deadline. So when abandoned, and I said, look, we can file again, but there is a likelihood that there are going to be new players on the register. And because they filed before you have now, your use is your use, and you may be the prior user, but we're going to have to oppose,
right? Or
we're going to have to move to cancel. And that kind of blew her mind. But it's like, this is what happens. You should, it's unfortunate, but maintaining those registrations, filing the applications, and then once you get the registrations, don't let them go abandoned.
Yeah, and so actually that's a good point. So once you apply, once you get it, there are periodic check-ins where you just have to raise your hand at the trademark office and say, still using, still out here.
Don't let them go away because you lose your line in the sand date.
So anyway, thank you, Kandis. I absolutely adore talking to Kandis about trademark. It's really fun. And I was telling Kandis earlier, like, this is exactly kind of what I would come up with as a law school professor on a trademark exam talking about.
It is a very good exam.
It's a good exam question. There's lots of good facts here. There's lots of good ways to walk through to do the analysis to figure out who gets this trademark, right? They both
Who's
want
on
it.
first?
Who's on first? It's back to baseball. Anyway, thank you for joining us. We are the Decoding IP team. We are at Protorae Law. You can check out all of our podcasts and live streams and blogs and all kinds of stuff on decodingip.com. And you can find biographical information about Kandis and me and Antigone and Clyde and the rest of our team on there too. And thanks for joining us on YouTube and Facebook and all of the places that you join us. And you can also get our podcasts, our Decoding IP podcast on iTunes and Android and pretty much anywhere that you can get your podcasts. If you have questions, if you have things you want us to cover, either in a live chat or in a podcast or on a blog, or if you have issues that you want to discuss and facts you want to run by us, give us a call. You can find us at Protorae Law, and we'll talk to you soon.